Welcome to Cleather Vessel today. We are diving into the important culture and education right enshrined in Article 29 and 30 of the Indian Constitution. These articles safeguard the rights of the minorities to protect their cultural identity and establish educational institutions. Article 29 Protection of Interest of Minorities. Now Clause 1. This clause ensures that any sections of Indian citizen with a distinct language, script or culture has a right to preserve it. This provision is crucial in diverse countries like India, where cultural identities are deeply interwoven with the regional and linguistic heritage. For example, communities with unique traditions such as linguistic rights of Tamil speakers in Kerala are protected under this clause. This clause prevents discrimination in admission to state-funded or state-minded institutions based on race, religion, caste, language or any such criteria. This ensures that no individual is denied access to public educational institutions due to their background. Now, relevant case law St. Stephen College versus University of Delhi, 1992. In this case, St. Stephen's College, in a minority-run institution, reserved seats for Christian students. The Supreme Court ruled that while minority institutions have autonomy to admit students, they must balance this with the merit-based admissions to ensure fairness. Second, Anura Roy versus Union of India 1983. This case expanded on the inclusivity of the educational rights, emphasizing that a state-funded institution must remain accessible to all citizens without bias. T.M.A. Pai Foundation versus State of Karnataka. This landmark judgment elaborates on the rights of minorities to establish and administer educational institutions. It upheld that the state could regulate such institutions only to ensure the quality of education but not infringe upon their autonomy. Article 30. Rights of minority to establish and administer educational institutions. This gives religious and linguistic minorities the right to establish and administer educational institutions of their choice. This means they can set up schools or colleges to preserve their language, religion and culture practices. For instance, a Gujarati speaking minority in Tamil Nadu can establish a school to teach Gujarati language and culture. Now clause A1 added to 44th Amendment. This clause ensures that if the government acquires property belonging to minority-run institutions for public purpose, it must compensate them adequately. Now clause 2. This prohibits the state from discriminating against minority institutions while granting aid. Minority institutions should receive state aid just like any other institution without a bias based on their religious or linguistic characters. Society for Unaided Private Schools of Rajasthan versus Union of India 2012. The court ruled that unaided minority schools are not obligated to follow the right to education right reservation norms. The decision reaffirmed the autonomy of minority institutions. Second, Kerala Education Bill 1957. In this case, Supreme Court reviewed the state power to regulate minority institutions and emphasized that such institutions must balance their autonomy with the broader goals of national integration and quality education. Commissioner of Hindu Religious Endowment versus Sri Lakshmindra Swaminar. In this case, set an important precedent by limiting excessive state control over religious and minority-run institutions, protecting their right to self-administration. The term minorities. Under Article 29 and 30, minorities are identified based on religious or language. India does not have a fixed definition of minority, but it is contextually applied. For instance, Christians are a religion minority in most states, but in Nagaland or Meghalaya, they are in majority. The right provided under Article 29 and 30 aim to preserve Indian culture, diversity and ensure smaller groups do not feel marginalized. Further cases explaining minorities' rights is Aziz Pasha versus Union of India, 1968. This case dealt with Aligarh Muslim University. The court ruled that the university was not a minority institution since it was established by an act of parliament, not by the Muslim community itself. Siddharaj Bai versus State of Gujarat 1962. The Supreme Court struck down the regulation that sought to interfere with the admission process of minority institutions, reaffirming that autonomy is central to Article 30 Clause 1. St. Xavier's College versus State of Gujarat, 1974. The court ruled that state regulation imposing conditions on the administrations of a minority institution must not infringe upon its fundamental right under Article 30. T.M.A. Pai Foundation versus State of Karnataka. This case is pivotal in understanding the extent of minority right. The Supreme Court laid down guidelines to balance the autonomy of minority institutions with a state regulation. For example, while minority institutions have right to admit students of their choice, they must ensure educational standard and not deny admission arbitrarily. Article 29 and 30 are crucial in protecting Indian diverse culture and linguistic heritage. They empower minorities to preserve their identity and contribute to the nation's rich mosaic of cultures. However, this right must coexist with the state duty to provide quality, inclusive, and education. Thank you for listening for today's episode of Clever Vessel. If you found this insightful, like, comment, and subscribe. Until next time, keep learning and stay curious. Thank you.